Good afternoon, everybody, and welcome to the second of our personal injury webinars for 2024. Some of you may have attended the first last week, which was Cassandra Williams talking about illegality. If you did, then I hope you enjoyed it. If not, then you can still sign up online and watch it on demand, as it were. This week, Sarah Hopkinson and I are going to be talking about pushing the boundaries of tort law. And over the next 30 or 40 minutes or so, we're going to go through areas at quite a high level, looking at how the Supreme Court over the last year and in the years running up to that have been looking at the boundaries of tort law. And it's perhaps a story of contraction as much as it is of expansion of those boundaries for reasons that we will explain. Throughout the talk, if you want to submit any questions, there's a chat box on the right-hand side of your screen where you can type questions. We'll also have a short break at the end of the talk where you can submit any questions, and then Sarah and I will do our best to answer those before rounding off. So in terms of content, I'm going to talk about the topics in bold on that slide. So duty of care. I'm going to spend a bit of time looking at tests for the existence of a duty of care and how useful they are and whether or not we should be applying them. I'm then going to look at what I think is probably the most interesting and the most fast developing area in the tort of negligence at the moment, which is the liability of public bodies to third parties. Sarah's then going to take the last 3 points on that slide. So that's liability to secondary victims for psychiatric injury, indivisible injuries, apportionment and causation, and then finally remoteness. So a good place to start, and a place where I tend to like to start, is what do the academics say about this? Well, it's fair to say that they think the law of negligence is a bit of a mess. And that's what David Ibbotson said in the quotation on the slide there. And the reasons for that were explained by James Plunkett in a book which is now a little out of date called The Duty of Care in Negligence. It's out of date because there have been quite a few relevant developments in the last few years since 2018 that I'll talk through in a few moments. But what's articulated there is the reason why the tort of negligence is a bit of a mess. Since Donoghue and Stevenson, now over 90 years ago, there's been a continual struggle by the courts to articulate a precise formula to capture when a duty of care does or does not exist. And the reasons for that are set out there, and it's because you have to draw a balance between capturing existing duties and permitting recognition of a duty in deserving cases, as he puts it, but at the same time excluding cases where there is no previously recognised duty, and also making sure that the tort is not open-ended and doesn't simply expand to an unwieldy degree. So it's a difficult balance for the courts to maintain, and that's the struggle that we will see when we look at how this has been dealt with in the Supreme Court. But just taking it right back to basics and what we were taught at law school. At law school, we were all taught some variation of the checklist that's on the slide there. To establish a claim in negligence, you need to show duty, breach, causation, remoteness, and loss. Sometimes the order is a little different, but essentially we have that checklist, and lawyers tend to like a checklist to work through in relation to these matters. So that's how it was taught at law school, and we'll come back to how that survives and whether or not that's still an applicable or appropriate analysis in a few moments. Specifically in relation to the duty of care, we were taught the three-stage test in Caparo. This is what it's fair to say I think we all grew up with. Was it reasonably foreseeable? Was the damage reasonably foreseeable? Was there a relationship of proximity between the parties? And then finally, and this is the one that tends to attract most of the attention, was it fair, just and reasonable to impose a duty? And we can see Caparo Industries now, I think, in administration or long since dissolved on the slide there, and that may be symbolic of how the test has come to be viewed in the later authorities for reasons we'll see. So that's the law school position and the way in which we all grew up. Let's look at how the Supreme Courts have been viewing matters. On the slide, we have the Big Crunch theory, which is a cosmological theory of the origin and fate of the universe. Starts with the Big Bang, the formation of a new galaxy, and then an expansion to the maximum point, and then a slow contraction to singularity, and perhaps a link right back to the beginning. The Big Bang in the legal sense in the tort of negligence was, of course, Donoghue and Stevenson. We then have an expansion, and the high watermark of liability was probably Annes and Merton. And then now we're in a phase, I would suggest, of contraction. The recent cases in the Supreme Court show a contraction of liability and perhaps a drawing in of the boundaries of tort law. Whether we head towards an implosion and a further bid ban, or whether we start to see another expansion, remains to be seen cosmologically as well as legally. And this is all overseen, and the guiding hand in this in recent years has been Lord Reid, who's on the slide there. He's the president of the Supreme Court, and we'll see that he's written the leading judgment in quite a number of the cases that we will look at. And getting into the granular detail of that, in the first Lord Reid judgment, we have the case of Robinson, Chief Constable of West Yorkshire Police. This was, of course, about police liability. And dealing with that Caparo test, Lord Reid sweeps aside any misconception that that might be applied in every case. It might be appropriate to ask whether or not it's fair, just, and reasonable on the particular facts of any case to impose a duty. Lord Reid makes the point that the Caparo test is only there for novel cases, and the law should instead proceed on the basis of analogy with established authorities, and therefore incremental development in the manner characteristic of the common law, as he puts it. So a warning shot there from the Supreme Court that we ought not to be applying that three-stage test too widely and too frequently. Now, another test that's come up in recent years is in relation to scope of the duty. And in the case of K and MNX a couple of years ago, Lord Hodge and Lord Sales, in their joint judgment, posited a 6-stage test looking at the scope of the duty. And this is quite a different framework analytically to that which we're accustomed to, and which I've put up a few slides ago. So we have the actionability question, the scope of duty question, the breach question, the factual causation question, the duty nexus question, and then finally the legal responsibility question. So quite a different analysis, and one which certainly some lawyers and some judges thought, or in a novel situation, or needed to be applied as a cross-check to make sure that they were making a decision that was consistent with the wider tort of negligence. And we'll look at how that fared in a moment. But before we leave K and MNX, it's worth noting that in his minority judgment, Lord Burrows, who of course comes from an academic background, posited a more conventional list of questions. He had 7 questions: duty of care, breach, factual causation, remoteness, legal causation, scope of duty, and defences. So separating out factual and legal causation, adding in scope of the duty and defences, but otherwise broadly consistent with that law school framework that I've looked at. And worth noting, different to the test that the majority set out, which really focused on that question about scope of the duty, Lord Burrows' test is perhaps a wider test, looking at the conceptual framework or structure of tort law, of the tort of negligence. So it's in some ways a different test, or with a slightly different focus, and perhaps one that could be applied more widely still. But in terms of the test, the majority's test, that didn't fare particularly well in the case of Armstead, which was a recent Supreme Court case from just a couple of months ago. And in the Court of Appeal, Lord Justice Dingermans had applied the 6-stage test set out by Lord Hodge and Lord Sales. And he'd gone through that as a cross-check at the end of his judgment on the basis of submissions that he'd received from the parties to the appeal. And counsel in the Supreme Court made submissions on that same 6-stage test. And this was shot down by Lord Burrows and by Lord Leggett in their joint judgment. And they said it was unnecessary and unhelpful to use those questions as a checklist because they were addressed to a case which involved the scope of the duty owed in a professional negligence context, as opposed to, as Sarah will explain in due course, Armstead, which really involved remoteness. So another warning shot here from the Supreme Court, not to get too excited by a multi-stage test that we can just use as a checklist to decide whether or not a duty is owed or any other aspect of the tort of negligence is made out. So another warning shot there. So moving now to the duty of care question and looking at the liability of public bodies to third parties, there are 2 key cases really that I need to look at in this context. The first is Enham Pool, and the leading judgment there was delivered by Lord Reid. who we've already seen, and then HXA and Surrey County Council, which was a decision of last year. Leading judgment there, joint judgment of Lord Burrows, again, who we've already seen, and Lord Stevens. Now, both of these were failure to remove cases. So there were claims by children against the relevant local authorities, children's services departments, and they alleged in broad terms that the local authority ought to have exercised their statutory powers to take them into care or make other arrangements for their to protect them from their domestic circumstances. And both of those claims were struck out by the Supreme Court as not disclosing an arguable duty of care. So looking at Poole, Lord Reid began by equiparating the position in relation to private individuals and when they owe a duty to public bodies and when they owe a duty. So the position is you approach a public body just as you would a private individual. And he swept away the old-fashioned and now well-established language of acts and omissions and said it was better to draw a distinction between causing harm, that is making matters worse, and failing to confer a benefit. That's not making things better. He thought that was a better distinction and more accurate language, and I think he's probably right about that. They encapsulate concepts better than just the words act or omission. And he made the point that, as in the case of a private individual, a public body may owe a duty where they have created a source of danger or where they've assumed responsibility to protect the claimant from harm. And he, having conducted quite an extensive review of the authorities, he concluded at paragraph 65 on the slide there, three points. First of all, public authorities may owe a duty of care in circumstances where the principles applicable to private individuals would impose such a duty, unless that would be inconsistent with or excluded by the legislation from which the public body derives its powers. Secondly, public authorities do not owe a duty merely because they have powers or duties in statute. And even if by exercising them they could have prevented the harm from occurring, that's not enough to give rise to a duty of care at common law. And then thirdly, public authorities can come under a duty to protect from harm in circumstances where the principles applicable to a private individual or body would impose such a duty. So as I've said, creation of a source of danger or an assumption of responsibility. And again, that's subject to any inconsistency with the relevant legislation. So in terms of an assumption of responsibility, Lord Reid went on to look at situations where on the authorities that has been found. So he gave the example of Phelps and Hillingdon. So that was an assumption of responsibility by teachers and educational psychologists as a consequence of their performance of their contractual duties. Then the case of Barrett and Enfield, that was a case where there was a care order and the local authority assumed responsibility in the performance of its functions under the relevant legislation in those circumstances. Made the point then that it isn't just cases in relation to information or advice. You can have situations where the defendant undertakes the performance of some task or the provision of some service to the claimant, and there's an undertaking that reasonable care will be taken in the provision of that service or in the performance of that task. So the existence of or the assumption of responsibility can arise, but it didn't arise in Poole. And what paragraph 89 there on the slide, you'll see Lord Reid making the point that it's highly fact sensitive and that in the circumstances of Poole, there wasn't any basis on which an assumption of responsibility might be established. So there was no, the children weren't subject to a care order in that case, and there wasn't any other relevant assumption of responsibility. So we have this concept of an assumption of responsibility. We have examples of how it might arise, but we don't have an answer really to the question of how exactly can it arise in this context where children are known to local authorities. That was picked up again in HXA. So in their joint judgment there, Lord Burrows and Lord Stevens first of all set out that Lord Reid's judgment in Poole now provides the authoritative guide to deciding whether there's been a relevant assumption of responsibility by the Children's Services Departments. And they made the point, paragraph 88, again, you have to equiparate the public body with a private individual and look whether there's a relevant assumption of responsibility, drawing again on the academic literature approved in Robinson in relation to when there may be a duty, so circumstances where there's an assumption of responsibility, where there's some the creation of a danger, some special level of control, or some obligation to protect due to the claimant's special status. So the conclusion in HXA, again, like in Poole, was there's no arguable duty of care in these cases, and the claims were therefore struck out. And the Court of Appeal was criticised for not grasping the nettle and striking the claims out in an area that the Supreme Court doesn't consider to be a developing or novel area of the law. But they go on to say, well, that doesn't mean there can never be an assumption of responsibility and hence a duty of care. It just isn't this case. So this idea of an assumption of responsibility is something of a chimera. We know it exists, but we don't quite know how to define it, and it's quite hard to identify what it would involve. Some elucidation of that in paragraph 107 of HXA towards the end of the judgment, acknowledging that it isn't just a case where you've got a care order like in Barrett, but if you have a temporary combination under Section 20 of the Children Act 1989, that's where the local authority will, on a temporary basis, take children into its care, and there will be an assumption of responsibility for the duration of that care, including the mechanics of return. And again, an analogy drawn with a private individual who takes a child away from their parent into care for a certain period. So again, nothing special about a public body. It's really looking at when the circumstances would arise whereby a private individual owes a duty of care. So we're getting closer to it, but we're still in certain circumstances where it's quite hard to see precise and absent a care order or the taking of a child into the local authority's care for a particular period, formally under Section 20 of the Act. It's hard to see quite how an assumption of responsibility would arise in circumstance if it doesn't in circumstances like in Poole and HXA, where the children are known to the local authority but not formally under their care. So again, an area where it may be more illusory than real that there could be an assumption of responsibility in those circumstances, perhaps. Moving over to a different context, and the police context, we have the case of Tyndall, and this is a slight step back in the timeline as it takes us back to 2022. And Lord Justice Stuart Smith, who's on the slide there, in quite a characteristically impressive synthesis of principles, set out in paragraph 54 9 different factors that the court has to bear in mind when looking at public authority liability, obviously with looking at this through the lens of police liability. So point number 1 on the slide there, just because the police or public authority have a power doesn't mean that they owe a duty. So the existence of a power that can be exercised isn't enough to give rise to a duty of care. And number 2, it follows from that the public authority won't generally be liable where it's intervened ineffectually. So it's in that situation, it's failed to confer a benefit that would have resulted if it had acted competently. That again doesn't give rise to liability. That applies even where the intervention involves it taking control of operations, so particularly relevant in the police context. If the police are taking control of the situation and coordinating the situation, that again doesn't give rise to a duty in and of itself. Knowledge of the danger, again, not sufficient to give rise to a duty to address it or to prevent harm arising from it. Number 5, the mere arrival of a public authority upon or presence at a scene of a danger, again, not enough to found a duty of care, even if members of the public might have an expectation that public authority will intervene to tackle the danger. So particularly relevant in terms of the police, but also perhaps other emergency services and other public bodies as well. Number 6, the fact that there's been an intervention in the past doesn't mean that there's any expectation and certainly no duty that they will intervene again in the future in the same way or at all. Number 7, a distinction between acting ineffectually and making matters worse. On the one hand, you're failing to confer a benefit. On the other hand, you're causing harm, making matters worse. So quite a stark dividing line between those two concepts that might, on the face of it, seem to be two examples on the same spectrum, but confirming that they're not. Number 8, the circumstances in which police and public bodies will have assumed responsibility to an individual member of the public are limited, not sufficient that the police are specifically alerted to a particular risk to either property, a group of the public at large, or to an individual. And that's drawing on the Supreme Court's decision in the case of Michael. And then finally, a relevant question to ask in relation to whether a public authority owes a duty of care to an individual is whether the relationship between the authority and that individual is any different to the relationship between the authority and other members of the same class as that individual. So you need something that really makes them stand out as someone to whom a responsibility has been assumed. So the position, again, on the basis of that synthesis of principle by Lord Justice Stuart Smith, is a drawing in of the circumstances and a very tight confining of the circumstances where a duty of care will arise in relation to the police or other public bodies to third parties. So that's where the law stands at the moment, having contracted from its high water mark and really very, very exceptional circumstances before a duty will be owed. I end with a note of caution and a point to watch, however. The note of caution is that we're talking here about the duty of care owed in negligence at common law. That's entirely independent from whether there might be any duty, operational duty, that arises under the European Convention on Human Rights. So in circumstances where we're dealing with a death or conduct by a third party that reaches the level of the Article 3 threshold, so a very severe level of ill treatment, in those circumstances, it's possible that a public body may owe an operational duty under the Convention, which would be actionable under the Human Rights Act. That's entirely independent of any claim in common law negligence. Just because there's no duty in common law doesn't mean that there can't be a duty under the Convention as actionable through different means. So tactically, that's a point to be aware of if advancing or defending a case of this nature. There may be other arguments or other avenues to success that arise from the same facts, even if in negligence the duty of care is unlikely to arise. And then the point to watch is in relation to Tyndall. You'll see from the slide there that was granted permission to appeal out of time last August. So we await a hearing date in the Supreme Court for that, and it's of note that the justices who granted permission to appeal included Lord Reid and Lord Burrows, both of whom have had quite a lot to say thus far about this question, and it stands to reason may have more to say. Notable that it's the claimant appellant in Tyndall who's been given permission to appeal, so that may signal either an expansion of the circumstances where liability is owed, or at least a clarification of when the police in particular owe a duty of care to third parties. It may, of course, be that we see, and perhaps likely that we see an alignment of that with other areas of public authority liability, Pool and HSA having both concerned children's social care in recent years. So it will be interesting to see how that fits into the wider tapestry of things, but that's certainly an area to look out for. So with that, I'll hand over to Sarah, who's going to talk first of all, I think, about liability to secondary victims for psychiatric injury.
Thanks, Tom. So let's dive right in with us, as Tom indicated, liability to secondary victims for psychiatric injury. I therefore, of course, am talking about the case of Pool. The Supreme Court, in fact, was dealing with 3 conjoined appeals, Pool, Polmere and Purchase, all of which arising from a clinical negligence setting, all concerning negligent failures to diagnose a life-threatening condition of the primary victim. Claims therefore resulted from close relatives of the primary victims who had sustained psychological injury as a result of witnessing either the death or the immediate aftermath of the death of a loved one. Majority judgment was by Lord Leggatt and Lady Rose. Just let's start with a reminder of the general rule, which remains that in the civil court, the death or serious injury of a human being cannot be complained of as an injury by another person. So the common law does not recognise one person as having any legally compensable interest in the physical well-being of another person. There is, of course, a statutory exception by way of the Fatal Accidents Act, whereby compensation is available for financial loss as well as damages for bereavement in certain circumstances. And then there's a common law exception, which is what I'm concerned with here, where a claimant has suffered personal injury consequent on the death or injury of another person. So where the claimant has witnessed the wrongful death or injury to someone that they love, i.e. they're a secondary victim and they've witnessed that in relation to a primary victim. The question that the Supreme Court was answering in Poole was whether or not the class of victims could be extended to include claimants whose injury was caused by witnessing the death or injury of a close relative from a medical condition which the defendant had failed to diagnose, as opposed to witnessing an accident in the aftermath. And spoiler alert, the answer of the Supreme Court was no. In relation to scope of duty, the Supreme Court said that it will vary with the circumstances and will depend critically on the purpose for which the service is provided. They referenced a case of K and M&X, which Tom already spoke about, and said that in this context, consideration of the purpose for which services are provided is equally important in determining whether or when a duty of care is owed by a doctor to someone other than their patient. I'm not going to delve more than that into the clinical negligence context in this talk. I do flag, however, that at our clinical negligence conference, which takes place in Nottingham on the 20th of June, my colleagues Philip Turton and Gareth McAloon will be covering this topic in a little more detail. Of course, what we know is there has to be proximity between the parties so as to give rise to a duty being owed by the defendant to the claimant's secondary victim. In the PI context, this will rarely be a novel question, and therefore we need not concern ourselves with Caparo and those other tests that Tom has referred to in his section of this talk. Where we know there is a duty, we're concerned with the control mechanisms as per Alcock and Frost, and there on the slide of the control mechanisms as set out by Lord Hoffman in Frost. So firstly, the close tie of love and affection with the primary victim. This may either be presumed, for example, in the case of a spouse or a parent-child relationship, or can be established on the evidence, that the claimant was present at an accident or its immediate aftermath, and that the psychiatric injury of the claimant has been caused by the direct perception of the incident or its aftermath, and not upon hearing about it from another source. There were 5 questions which the Supreme Court addressed in the judgment of the court, and again, another spoiler, the answer to all of those questions, no, 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 no. Let's take them each in turn briefly. Must the claimant experience a sudden shock? This question can be taken alongside the second, must there be a horrifying event? As what was said by the Supreme Court is that this is not, neither of these in fact are requirements established by Alcock and confirmed in Frost. In engrafting onto those requirements, additional requirements of needing to prove that the claimant's injury was caused by the mechanism of a sudden shock to the nervous system and was a sufficiently horrifying event, the law has, in our opinion, taken an unfortunate wrong turn, which these appeals enable us to correct. So that correction duly made. We move on to the third question. Must the event be close in time to negligent act or omission? The Court of Appeal could see no reason why a gap in time, short or long, between the negligence and the event caused by it should affect the defendant's liability, nor could the Supreme Court, nor in fact could the defendants by the time it reached closing submissions in the Supreme Court, because this point was in fact conceded, and rightly so, so said the judgment in the judgment of the court. The next question, must the event be the first manifestation of damage to the primary victim? Again, the Supreme Court thought that the Court of Appeal got it right. It'd be illogical to make the liability of a defendant for an injury caused to the secondary victim depend on whether the event witnessed by the claimant was or was not the first manifestation of damage to the primary victim. And then the fifth question, should damages be recoverable in the absence of an accident? The Supreme Court identified 3 ways in which the occurrence of an accident is integral, both to the reasons for recognising the category of claims by secondary victims arising from an accident and in defining the limits of this category. 3 important features are set out there on the slide in relation to accidents. It's a discrete event. The witnessing of an accident involving a close family member is likely to be disturbing and upsetting, and it's often difficult, in fact, to distinguish between primary and secondary victims in those circumstances. The Supreme Court was asked to draw an analogy between the accident cases, McLaughlin, Alcock and Frost, where one is concerned with illness caused by witnessing an accident or its immediate aftermath involving a victim with whom the claimant has a close tie of love and affection, and cases where the claimant does not witness an accident but suffers an illness as a result of witnessing such a person suffering a medical crisis. It was the Supreme Court's view that no such analogy could reasonably be drawn, and thus the claimants were ultimately unsuccessful. So where does this leave us? There has been, in my view, helpful clarification as to what is, or rather what is not required, with those 5 questions having all been answered in the negative. Poole does appear to significantly restrict secondary victim claims in the clinical negligence setting. There remains this question of when doctors may owe a duty to third parties, and as per the K and MNX case, the focus in answering such a question is likely to be on the purpose for which a service or services were being provided. So let us move on to the next subtopic, indivisible injuries, apportionment and causation. I'm talking about the case of Holmes. In this case, the Court of Appeal resolved the question whether material contribution to an indivisible injury is sufficient for causation to be made out. A particularly important decision, therefore, in the context of disease and clinical negligence. So let me pause here for another plug for our clinical negligence conference, where Tom will be speaking once again, this time alongside Jane Adams KC, and he'll be covering this case in a little more detail. It's a case in which, in fact, Tom was led by Patrick Lim KC in the Court of Appeal. In a nutshell, what we know from Holmes is that in the case of an indivisible injury, such as Parkinson's disease, a tortfeasor who makes a material contribution to the injury will be liable for the whole of the claimant's injury. The claimant does not have to show that the injury would not have happened but for the tortious exposure for which the defendant was responsible. And to that extent, the claimant in fact succeeded on the law. And in the wider scheme, this is a case which is likely helpful to claimants. Unfortunately, on the facts of Holmes, that the claim failed for the reasons that I'll now address. In a claim such as this, once the legal test has been identified, i.e. material contribution, there are 2 questions to be addressed. The first is generic causation, i.e. is the agent being complained of in principle capable of causing the disease or condition complained of? And then individual causation, i.e. in this particular case, did the agent cause the particular condition in this particular claimant? Unfortunately for Mr. Holmes, the state of scientific knowledge is simply insufficient as things stand for this to have been established for the reasons given there on the slide. Whilst TCE was a risk factor for Parkinson's disease, it didn't go further than it simply being a plausible mechanism. In relation to individual causation, in any event, the decision of the Court of Appeal was that there was no evidence in this case to make out individual causation, notwithstanding the finding already made on generic causation. So what next and where do we go from here? Well, interestingly, Lord Justice Stuart Smith did leave open 3 areas or questions on the basis that they didn't strictly arise in Holmes due to the facts of the case. Those are there on the slide. The first is apportionment. Now, drawing on the authorities such as BAE Systems and Hatton, it was floated that it might be possible to carry out a second-order apportionment exercise at the damages stage, so only after the material contribution threshold has been cleared at the causation stage. Lord Justice Stuart Smith described these as important and difficult questions, best left but left open for another day. Secondly, the oversubscribed causes, i.e. where there are more causes than needed to, in fact, cause the event complained of. Again, this is referred to as being an interesting question as to whether causation can be made out, and if so, whether the claimant can, in fact, prove any actionable loss in those circumstances. This particular topic has attracted a lot of academic interest, and it may be that the courts are led by that and influenced by that when this next comes before the appellate courts for argument. And then thirdly, the ambit of Wiltshire. This didn't arise and so wasn't decided, but there is an important question again, which remains as to the dividing line between a Wiltshire type case with discrete potential causes and a Bonington or Holmes type case with cumulative potential causes. So up next, remoteness in the tort of negligence, and this is the case of Armstead, which Tom's already referred to in brief in his section of today's talk. The facts are that the defendant tortfeasor caused damage to a car which the claimant had hired from Help Hire Limited. The claim was for the cost of repairs, but also for payment of £1,560, which had been claimed from the claimant by the hire company under the agreement for loss of use for 12 days while the vehicle was unavailable to the hire company whilst it was being repaired after the claimant's hire had ended. At first instance, the Deputy District Judge dismissed the claim in its entirety on the basis that the claimant had no proprietary interest in the vehicle and so no right to recover economic loss at all. On appeal to the recorder, the defendant accepted that the claimant was a bailee in possession and as bailee of the hire car was entitled to recover damages for the diminution in value, i.e. the repairs element. So there was a concession that the claim had wrongly been rejected in relation at least to the cost of repairs. But the clause 16 sum, that 1560, remained in issue. The recorder held that that sum was not a reasonable estimate of help hire's actual loss of use, and so the claimant's liability to pay help hire that sum was not reasonably foreseeable as a consequence of the collision. The recorder also held that the sum was relational economic loss, which was not recoverable. The Court of Appeal rejected the claimant's appeal for several reasons, including three important ones included on the slide. First, that the Clause 16 liability was a form of pure economic loss. Second, that it did not represent a genuine or reasonable attempt to assess the likely losses to be incurred by help hire, the hire company. And third, that because of that, the loss claimed was not reasonably foreseeable and was too remote to be recoverable. So before getting on to remoteness, just a brief note on bailees in possession. This has now been clarified by the Supreme Court in the event that such clarification was necessary, that as against the negligent tortfeasor, a bailee in possession does have absolute possession. And then secondly, in relation to pure economic loss, in general, pure economic loss is irrecoverable in the tort of negligence. So where loss is suffered as a result of damage to property, it is not recoverable if the claimant has no interest in the property that is damaged. In this case, of course, the claimant did have a possessory title to the car as bailee in possession, so this was not and could never have been said to be pure economic loss. Having dealt with those two little points, let's get on to remoteness then. So the Supreme Court has set out some helpful clarification as to the law on remoteness of loss. Where it is shown that a loss has factually been caused by the defendant's breach of duty, there are 5 principles capable of limiting damages recovered by the claimant, and one of those, as you can see there, number 2, is remoteness. And the Supreme Court said there's no reason in principle why recoverable loss should not include a contractual liability to a third party, provided that liability is consequential on physical damage to the claimant's property or property in which the claimant has an interest. The Network Rail case was referred to in the judgment. In that case, there had been physical damage negligently caused to a revenue-generating property, and the loss recoverable by the owner of that property from the person who caused it includes a sum payable under an agreement with another party to compensate the party for its loss of revenue resulting from the damage. And so just as in the Network Rail case, liability was made out, so too in this case, with a finding that the loss was not too remote. There are principles or findings on remoteness by the court, and I've set them out there, a summary of 5 points that were made. A loss will be too remote if the type of loss suffered was not reasonably foreseeable at the time of the breach of duty. But a note there is that the manner in which the loss occurs doesn't have to be reasonably foreseeable. It's just a question of whether the type of loss suffered was reasonably foreseeable. Second, a reasonably foreseeable type of loss flowing from damage to a hire car is financial loss resulting from inability to use the car. To fall within the reasonably foreseeable type of loss, it's necessary for the claimant's contractual liability to reflect the loss of use of the hire company. Number 4 refers to the underlying policy reason for the remoteness rule is to ensure that an excessive burden of liability does not fall on the defendant. Without an insistence that the contractual liability is a reasonable pre-estimate of the hire company's loss of use, a contractual clause might specify a sum that would impose an excessive liability on the defendant, hence that important restriction. And then number 5, the loss comprising the claimant's contractual liability under clause 16 would be too remote if clause 16 was not a reasonable pre-estimate of help hire's loss of use. In relation to the burden of proof, the Supreme Court said, and I agree, that there was actually a surprising absence of authority on the question of who has the legal burden of proof in relation to remoteness, but no longer, because the Supreme Court has told us the burden is on the defendant to plead it and to prove it. In Armstead, RSA, the defendant had not pleaded that the Clause 16 sum was not a reasonable pre-estimate of help hire's loss of use, and no argument to that effect was actually made by RSA at the trial, so there was no finding of fact to that effect either. In those circumstances, the Supreme Court's view was it wasn't open to the Court of Appeal to make factual assumptions which were entirely unsupported by evidence. The defendant hadn't put before the court evidence that the Clause 16 sum was not a reasonable pre-estimate. Another question asked and answered in the judgment was, what if the loss was not a reasonable pre-estimate? Would that mean that Ms. Armstead would recover no damages at all in respect of loss of use? And the answer is no. In that scenario, the claimant would be entitled to recover as damages such lesser sum as did represent the hire company's reasonably foreseeable loss of use. So then, drawing together that which Tom and I have spoken about today in a very short conclusion, know your basic tort principles, I guess, is the main lesson. Try to argue in relation to analogy, i.e. incrementally, and put to one side where not absolutely necessary those tests that are for novel situations only. And in our view, any future expansion or perhaps more likely contraction looks to be made by reference to first principles. So that there's really nothing more to be done than know them and know them well. Thank you very much for watching this webinar on demand. If you do have any questions, please feel free to contact us using our contact details provided on the screen.